Welcome to the Crystal Fideli podcast. I am your host, Crystal Fideli. I am a social researcher and policy analyst, speaker, consultant, and an award-winning nonprofit founder and executive director. And all of my work focuses on helping us to understand coercive control, helping organizations to understand coercive control so they can respond better, and helping individuals understand coercive control so they can navigate the systems that they need to navigate better. And here on the Crystal Fideli podcast at large, we examine when institutional norms and practices diverge from what the research calls an evidence-based approach, being based on science, research, the law, etc., and instead reverts into using what the research calls a practice-based approach based on tradition and opinion, and how it causes an immense amount of harm to very vulnerable and marginalized people. And that leads me into introducing you to a special series we are doing here on the Crystal Fideli podcast called When Coercive Control Turns Financial, the Family Court Response and the Cascading Consequences. We see in the research and in practice time and time again when a woman attempts to set boundaries on the coercive control that she is experiencing, how the coercive control does not stop, because that's not how it works. Coercive control does not stop when a woman sets boundaries. It just switches forms and it intensifies until a person in power or an institution steps in and stops it. So she attempts to set boundaries, and most often it switches to financial. And we examine the family court's response and how that leads to so many cascading consequences. So welcome to the series.
All right. So welcome back to the Crystal Fideli podcast. And today I have with me a special guest, Erika Sussman, and she is the founder and executive director for the Center for Survivor Agency and Justice. And so I want to introduce my guest. So Erika Sussman, as I said, is the founder and executive director of the Center for Survivor Agency and Justice, a U.S.-based national organization that advances economic equity for survivors of gender-based violence. Under her leadership, CSAJ has established the principle that there is no safety without economic security. That is so true, which is now understood and acted upon field-wide. Before founding CSAJ in 2007, Erika identified a critical gap. Mainstream legal services were failing to address survivors' comprehensive economic needs. So true. She created CSAJ to translate survivor-centered theory into practice. During her tenure, CSAJ has launched the Consumer Rights for Survivors Initiative, the only national project building attorney capacity to address survivors' economic needs through consumer law. The Mapping and Advancing Equity Project, which challenges the field to advocate for safety through an equity lens, created the SEED dashboard, the only national survivor equity data tool designed to fuel systems change, and pioneered the Survivor Advocate Advisory Board, a model of survivor-led policy and systems change. She founded and leads CSAJ's National Coerced Debt Working Group, an interdisciplinary coalition that has passed a groundswell of coerced debt legislation in multiple states and made federal policy advances. Prior to founding CSAJ, Ms. Sussman served as the senior attorney of the Legal Assistance Providers Technical Outreach Project, a national project of the Pennsylvania Coalition Against Domestic Violence, which offered a technical assistance to civil attorneys and advocates funded by the Office of Violence Against Women. Ms. Sussman taught a course on law and violence against women at Cornell Law School and Georgetown University Law Center's Domestic Violence Clinic. As a litigation associate at Swidler Berlin Sheriff Friedman LLP, she provided pro bono representation to domestic violence survivors and co-counseled with the ACLU, a racial profiling class action lawsuit. Immediately following law school, she served as law clerk to Justice Gregory Hobbs of the Colorado Supreme Court. Ms. Sussman earned her JD from Cornell Law School and her LLM in advocacy from Georgetown University Law Center. She has published numerous articles and served as faculty for various academic and practitioner workshops related to gender-based violence, with a particular emphasis on survivor-centered centered advocacy and economic justice. So, Erika, welcome to the podcast. I'm so happy to have you here.
Thank you. It's great to be here.
Yay. Awesome. So let's get started. So the first section here is reframing domestic violence, coercive control as the governing model. So in this section, I always like to reframe how we understand domestic violence for our audience. So traditionally, domestic violence has been understood through an incident-based model focused on discrete acts, often emphasizing physical violence. This shifts that understanding towards coercive control, though, as the governing model, which reflects an ongoing pattern of power, control, and entrapment across multiple domains. Within this framework, financial control is not a secondary issue, but a central mechanism. And when it is not interrupted, it can persist and intensify over time. So, Erika, from your expertise and your perspective, I wanted to start with the framework itself. Could you explain the difference between an incident-based model of DV and a coercive control framework and why that distinction matters?
Sure. So I think that historically, when folks think about domestic violence, often they're looking at it in a very incident-based way. In other words, domestic violence is often thought of as discrete acts of physical violence of one person against another. And tends to be very much coming from a criminal justice sort of lens. Some of that actually was strategic, I think, initially, right? Because the violence against women movement was at a time when there was no recognition of domestic violence. There was a real desire to get some sort of legal protection for people who were being impacted. And so the criminal justice model of incident-based crimes was sort of the go-to model. But what we know about that is that really there's a disconnect between that type of incident-based model and how coercive control actually presents itself in real life. Because we know that while it is true that there are instances of violence and coercion that do take place, they're happening within the context of a much broader and systematic use of violence, threats, intimidation, isolation, and control, all of which are really designed to limit an individual's autonomy and agency. And that is, kind of the distinction between incident-based models and coercive control, because when you look at that much larger pattern, you're able to see how context really matters a great deal, and that each individual action can't really be looked at in isolation because it derives its meaning from a much broader scope of coercion.
Yeah. I never made that connection before until you said it that, this incident-based, sort of physical-based model of looking at domestic violence, it's really a criminal sort of law, sort of lens. Whereas I guess when we look at it from a coercive control lens, making that this is more the civil law lens. I don't know, maybe I'm describing it differently than how you were saying it, but I don't know. It just kind of, for me, when you were saying that, that's kind of what I was getting from it. Am I kind of on the right track there?
Yeah, I mean, I think absolutely. In order to get the power of the criminal legal system to pay attention to domestic violence as something that wasn't at that time just a private matter, but was really something deserving of legal protection. The criminal justice system was sort of turned to as the immediate way of addressing that. Actually, with and that was done in the face of a lot of concern and a lot of uh, folks expressing the perhaps unintended consequences of leaning on a model like that. both in terms of like how it describes things, but also in terms of the um, some of the negative impacts of relying on the criminal justice system as the way to address domestic violence alone. Certainly, marginalized communities have experienced a lot of negative impacts as a result of that. And and I think, from an agency perspective, a survivor agency perspective, often individual survivors find themselves struggling to really be able to control the process as much when it's limited to those criminal um, systems. And so, yeah, but so that's one piece of the shortcoming, but also I think just that it's not really a full description of people's experience, right? Like we know that um, when people are experiencing domestic violence, the power of it um, really derives from the fact that it's happening in this much broader context of coercion, and that even individual threats that on their own might seem benign are really much more dangerous because it's happening in this broader context of threat, intimidation, and past instances of violence.
Yeah, definitely. And another piece of this is that coercive control is not static, right? So it shifts depending on access and opportunity. So, can you speak to how coercive control adapts across domains such as financial, emotional, and legal contexts over time?
Sure. So, there are lots of ways that people can exercise coercive control. I think that our culture and our society is most familiar with physical violence as being kind of the quintessential form of domestic violence. But what we actually know is that um, that's not really, certainly not the only form. And in fact, economic coercion is even more common than physical violence.
Yeah.
So, in a study that was conducted by Adrienne Adams and her colleagues back in 2008, um, they had developed a scale of economic abuse and conducted lots of interviews with women all across the state of Michigan who were receiving services. And they, administered this economic abuse scale. And what they found was that 99% of people who they interviewed reported that they had experienced economic abuse as part of the domestic violence experience.
Wow, I didn't know that was an actual data point. I've heard 99%, but I thought, oh, it's just somebody, making a claim and hyperbolic. Like, I wonder what the actual data point is, but I didn't know that was an actual data point. You just taught me something today. I learned something new.
Yeah, yeah. So that percentage is actually higher than the percentage of people who reported physical abuse as being part of their experience.
Yeah.
And so we know that, that is just almost uniform part of coercive control, that economic coercion is really one of the tools that entraps women in relationships and causes pretty dramatic types of harm. And when we talk about economic abuse as being part of that experience, the definition of that is that it involves behaviors that control somebody's ability to acquire or use or maintain economic resources, which basically threatens their economic security and their potential to be self-sufficient. Um, so again, it goes back to this idea of control, and that without having access to those resources, the abusive partner is able to really maintain control over their partner. And there are lots of different ways that that shows up. So when we talk about it. Sometimes you can talk about it in terms of, when an abusive partner is preventing survivors from acquiring resources, by interfering with their attempts to obtain or maintain employment or to further their education. And that could show up in many, many different ways. But some examples of that might be somebody turning off an alarm clock the night before a job interview, inflicting visible injuries so that they won't be able to go to that interview or to work the next day, refusing to provide childcare, making sure they don't have transportation, or even just physically restraining them from being able to go to work or to school. And some of that also is more prominent in the actual workplace. So somebody could show up at a survivor's workplace and harass her or her coworkers there. And so, that kind of way of interfering with the survivor just acquiring resources is certainly like one very clear way that that takes place. Another way is by batterers who are preventing their partners from using the resources that they already have. So that could be imposing, an allowance, or denying them or their children access to food or other basic necessities, hiding money that she may have earned by herself or that belongs to the both of them, so that she doesn't have access to that. And so those would be examples of using resources, preventing survivors from using the resources. And then the last piece, which I want to talk about just briefly, but maybe we can get into it a little bit more later, is when batterers are really intentionally exploiting survivors' resources. It's not just an interference, but it's a very deliberate attempt to sabotage their economic well-being. So certainly stealing money, destroying property, cutting off utilities, and then just generating lots of debt in their partner's name. We know, anybody who's ever been in any type of intimate relationship knows that it's very common for someone to have your access to your personal information, your birthday, your social security number, all of that. And so it is common for abusive partners to use that information to generate huge amounts of debt by opening up credit accounts without knowledge or through coercion. And we talk about that as a real predominant form of financial sabotage. Of course, that all of these things that I've just shared with you, the thing that they have in common is that they lead to decreased options for survivors, right? The more somebody's resources are depleted, the fewer options they have, and the less opportunity they have to be safe. So
yeah. And even, I always explain it like whack-a-mole, like, right? Once a survivor kind of cuts off the domestic abuse, happening through, certain forms, like maybe psychological or physical or sexual or whatever, oftentimes in my work, because, we support women when coercive control has turned financial, right? And they have to now navigate family court. It's like, it doesn't stop. Then it always turns towards finances. Boom, she's cut off, right? But something that I see a lot is that the perpetrators of coercive control will sort of have her caretaking burden. And I hate that word burden because children are not burdens. My children, personally, I think they're the best things that ever happened to me in my life, the best things I ever did. But that's just the term, right? The caretaking responsibility burden like goes up because now they're with the kids 24/7 around the clock. his caretaking burden goes way down. And I say he because historically and still today, economic abuse disproportionately, regardless of intent, but in effect, I think the data shows, and that's what I see in my practice, affects women more than men. But anyway, so that's why I say he. But anyway, so yeah, his caretaking burden goes down. He has actually more freedom to work even more, whether that's through his own business or W-2 employment. And so she's still enabling the income, but he basically takes all the money. And she's lucky if if the family court, even puts in a household expense order. And so he has, an elevated lifestyle. And so, yeah, it just shifts forms. It doesn't stop, it just shifts forms. So, yeah. And so then getting into the next question. So, I also want to focus specifically on financial coercive control. So, when it shifts, to financial, from your perspective, how does financial coercive control operate as a primary mechanism, and what role does it play in maintaining control? And I know that you kind of, touched upon that. I guess more, if you could think about it in terms of the family court, like I said, if she's stopped the domestic abuse from happening in certain ways, and then now it shifts to financial, and now she has to navigate family court from your perspective. Yeah, like how does that operate as a primary mechanism, and how does it maintain his control?
Yeah. I mean, I think one of the pieces that has impact on um, her financial standing before she even enters the family court system is this issue around debt that I started to talk a bit about, which inevitably is going to be impactful in the family court setting. When we talk about coerced debt, really what we're talking about are non-consensual credit transactions that happen, where one person is using coercion in order to really dominate the other person. And so that could be fraudulent in nature, right? Somebody could buy items online using their partner's credit card information or their partner's social security number, or take a loan without them knowing. But the other way is much less straightforward, and that's really through debt through coercion. And it involves like a force or threat to harm her, to basically compel the partner to take on debt that they otherwise wouldn't have. So there's a demand that, and this goes back to your question before about the distinction between incident-based models and coercive control models. The reason why debt through coercion is so effective is that that demand is, there's always a threat of consequences connected to it for not complying. So they might pressure their partner to sign their name on a vehicle loan with the unspoken or sometimes spoken threat that if they don't do this, they're really going to be sorry, maybe physically, psychologically, emotionally, financially. Some harmful consequence is going to ensue if they do not sign for that loan. So the threat there is real, and makes sense within the broader scheme of things, and I think is often misunderstood by our systems, our financial systems, our court systems, and has huge implications for people, prior to entering family court, but certainly in the family court context. And it's very common as well. Basically, about half of survivors report that they have experienced coerced debt, and that as a result of that, their credit report is being negatively impacted as a result of of that destruction, of that debt related harm. So, I think it's also important, speaking of like individual instances versus the larger context, the costs of these debt related impacts are enormous because it's not just, that somebody owes a debt for a particular thing. Of course, when these course debt um, injuries take place, it leads to a whole cascade of consequences that are damaging their credit. Yes, of course, but then what happens within our society right now around credit, it's a major determinant of people's access to resources. If your
Yeah.
credit has been destroyed, right, you can't get access to housing. You can't, many employers are checking people's credit reports prior to offering them jobs. Utilities are inaccessible as well, and really all of the basic material resources that you need to be safe. Um, so, again, just looking at that in terms of like what are the long-term impacts of economic coercion and in particular coerced debt, they are rippling and quite profound over the life course.
Yeah, definitely. And one of the things that I think of is this woman that I worked with, and she had told me that her own a family law attorney had said to her, "Well, it's your fault if, your lifestyle has degraded and, you haven't, gone to the doctor in the past, year or whatever," because she was a stay-at-home mom. And then overnight, she cut off the abuse happening through certain ways, and then she was cut off, right? And left with the children, around the clock. And but now she lost access to all of the income. And so she had nothing. And so she couldn't go to the doctor and stuff like that. And the family law attorney had said to her, "Well, it's your own fault that you lost access to medical care because you still could have gone. I mean, I know that you would incur debt, but it's your own fault. You still could have gone and incurred debt and with the co-payments or whatever." And I was
Mm,
just like, I was thinking, I was like, wait, first of all, that's not how that works. A lot of providers won't see you unless you pay the co-payment. Second of all, though, but like, why should she have to incur debt? Because, I don't know. I guess we lack procedure here in the state of New Jersey for ensuring that, an equitable pendente lite analysis is done in a reasonable amount of time, not for the over a year that she
mm,
had to go through,
mm.
literally having, SNAP benefits and, no other liquidity while he's buying a second, vehicle and, storing up his coffers with tens of thousands of dollars, et cetera, et cetera. So I'm not sure if kind of that's the wavelength you were, speaking on, but that's just something it reminded me of
Yeah.
just the legal family law system, just kind of handling it that way and almost again, regardless of intent, but in effect, that positively reinforcing her having to incur debt. I don't know.
Mhm.
So,
Yeah, I mean, I think also what you're bringing up is just the fact that the enormous role that individual actors in our legal system play. I mean, that's somebody's attorney who's telling her that. We could point to many instances of judges or court clerks or other folks within the court system who bring their own biases into how they react to survivors and sort of what those systemic barriers are. Um, Sometimes they're even more, I would say, violent. The impacts are even more violent than the experience of violence that they've had at the hands of their abusive partner,
yeah.
right? When you're seeking help and the systems that are supposed to help you are actually compounding the harms. We have to kind of ask ourselves how effective of a system that really is.
Yeah.
So,
Well, not very effective, I guess. Well, effective for the coercive controller because time and time again, I mean, I just see, the coercive controller get positively reinforced, the survivor get negatively reinforced for seeking help to escape the coercive control, and again, the coercive control getting positively reinforced for perpetuating coercive control. And really, like, what incentive does the coercive controller have to create a more equitable structure? I mean, the system default is set up to benefit the income earner. And yeah, well, I guess that's what the research calls the institutional betrayal, right? So, but yeah, so, and then we get into system entry. So procedural demands versus constrained capacity. So this section focuses on the point of entry into the system. So individuals experiencing financial coercive control often enter already under significant financial, psychological, and legal constraint, while the system simultaneously requires those capacities for effective participation. And so this creates a structural mismatch where access to justice depends on conditions that may have already, be limited or absent by coercive control, contributing to inequity over time. So I want to start with the conditions at entry. We've kind of touched upon them already, but um, from your perspective, do you
I
have?
think there's a lot more to touch upon there.
You're right about that. I know. I always have this thing. I always feel like, oh darn, am I repeating my question again? And so I
Not
always
at all.
I always want to be sensitive to that.
Sadly, those barriers are high, and so there's a lot to talk about there. Yes.
Yeah. So can you describe the typical conditions under which a controlled party enters the system, the family court system, particularly in contrast to the controlling party?
Yeah. So, you know, so the organization that I am the founder and executive director of is called the Center for Survivor Agency and Justice. And when we started doing our work, it was mostly working alongside individual survivors and individual advocates and lawyers in the field, um, supporting folks in really strategizing about how to navigate their way to safety. And that is continues to be a large part of the work that CSAJ does. But the more that we have worked with individual survivors, advocates, lawyers over the years, the more we have seen that the issues that survivors face are not just one-offs, they're really systemic in nature. And more particularly, the economic issues that survivors face are not just individual problems that require individual solutions. They too are systemic issues in need of systemic approaches.
Although the family court system seems to treat it like it's an individual issue, but it's like, no, it's systemic family court. Sorry, go ahead.
Right. Well, when you see the same issues come up with individuals over time, one needs to take a step back and say, wait a second, the system is consistently responding in a way where it's having this impact. So, those systemic barriers present huge challenges to survivors in their efforts to really navigate their way to safety. It limits their access to economic security and constrains their options for safety that are available to them. So, one of the ways that this shows up is in terms of what we talk about as limited resource availability.
Mm-hmm.
So we find lots of times that the choice to seek legal protection is in direct conflict with the survivor's economic security.
Yeah.
Folks who have fewer resources or who, may not be primary breadwinners have to contend with, crazy hours of operation that don't really mesh with their own schedules, having to take off days from work in order to access the courts, having to find childcare in order to seek legal remedies, as well as transportation, right? When you think about folks, depending on their context, who may be in more rural areas, being able to get to a court is no easy feat. In urban environments, we're talking like multiple bus rides and things of that sort. So all of those resource related issues But also limited resource availability in terms of, abusers really exploiting system barriers based on their knowledge of survivors' limited access to resources.
Yeah.
We know, of course, that abusive partners engage in really protracted litigation, knowing that that process is likely to tire out their their partner or former partner, and that the resources that are required to engage in a custody hearing or other family court process is going to deplete that person of economic resources, with, I think, the hope that they'll give up. Um, so just that piece, that limited resource availability piece, is a huge systemic barrier that I think is problematic in and of itself. Um, Another is, we were kind of talking about a little bit earlier. It's just the response of folks within systems, just a
Yeah.
poor service response. So,
Yes. Horrible customer service.
mhm. I personally will never forget. I remember when I used to represent people in the District of Columbia Superior Court a while ago and years ago. And, I remember people who spent their whole days, their whole day waiting for their case to be heard. And there's one woman who I remember was there, she had gotten there at 8 a.m. trying to get a civil protection order. It was like 4 o'clock in the afternoon. She was still waiting and she needed to go get her kid from daycare. And a court clerk literally said to her, "Well, you need to decide. Do you want to get your child or do you want to get a protection order?"
Wow.
Right? So it's those responses, or even the example of the attorney that you had mentioned before, right? People really placing survivors in impossible circumstances where where they're forced to choose between their physical safety and their economic security. Um, and those systemic barriers are quite real and frequent. So another example of that, of course, are just the ways that biases of court folks in court show up in terms of their access to justice responses. So the general court preference for preserving a two family um, household that leads judges to award custody to abusive parents despite seeing all of the dangers that they pose to their children and to their former partners, or just judges that are not particularly informed about the nature of domestic violence. So, poor service response is definitely one systemic barrier. Um, and then we also just see like policies themselves as being systemic barriers that prevent survivors from accessing justice. Whether that's like custody policies and laws themselves. I was talking earlier about credit and the impact of debt on credit, and we know that policies that rely on credit checks are really have inequitable impacts on domestic violence survivors who have experienced abuse, because it's not the assumptions that are made about good credit really are not applicable to somebody who is holding liability for credit that's for debt that somebody else has accrued in their name. So credit checks serving as a barrier, like I talked about before, nuisance ordinances that happen in the housing context where people have to choose between enduring abuse and being evicted from their home. There are
Yeah.
just so many ways that these policies create inequities for domestic violence survivors that are create problems from the outset. Um, yeah.
Yeah. I was going to say earlier when you were talking, I forget exactly what you said, but I was like, oh wait, well the family court system, the judges and the attorneys, they have an answer for that one. It's oh gosh, what were you saying earlier? But my response was, well, their answer to that one is, well, the past is in the past. Just, let's keep it moving forward or whatever. We
Oh,
can't change the past. We have to keep moving forward.
right.
Yeah, that's like one of their favorite, solutions. Um, I think that's a really harmful solution, but yeah,
Yeah,
just
I mean, sadly, that's a that I think that's not limited to the family court, right? We
mm,
see that in so many places
yeah,
in our legal system where there's history either between individuals or between entire communities
yeah.
where that history is quite relevant to
Mm.
people's lived experience and not looking at that broader context really um, does injustice. Yeah.
Yeah, but it's interesting enough because it's like the past is pertinent to the present and the future, and it's not going to change. The same pattern's going to keep repeating if we don't address the past. So it's just,
100%.
but I got my microphone went out for a second. Um, yeah, and just all of these, oh, man, I have so many stories of just even like legal aids, attorneys, just how they treat their client who is the survivor. I have one woman I remember, she was crying and hyperventilating and wanting to go to the hospital because she's like, my attorney has threatened that she's going to withdraw if I don't do what she wants me to do. Or another attorney saying, well, you're violating your attorney-client agreement because you are not being forthcoming about all of this information. And she's like, no, I will be forthcoming. I just want to make sure that you're not going to request this relief because I don't authorize that. And it just all this, like these coercive, sort of pressure, tactics that I think is so unfair that these survivors have to, or one attorney saying to the woman, well, Miss Such and Such, they ordered household expenses. What more do you want? And she's like, well, money for food, medical needs, to take my kids out to an ice cream, just extra cash if I have a car repair while they're stocking thousands upon thousands plus, each month. And it's just, I don't understand like why we treat survivors this way. I don't know if we're trying to manage expectations because we're not willing to go out and actually fight for what they're entitled to. And man, that's a whole project that I would love to do is get, survivors on to talk about the specific things that they have been told by judges and family law attorneys, and not a way to criticize them, but just to say, hey, like, this is what's happening. And regardless of intent, in effect, this is what it's doing. So maybe we can make some changes unless we don't, care and we're fine with, doing that. But
Yeah,
anyway,
I mean, I think what you're elevating are two things. One is that there is a tendency within the family court system to disregard the fact that are that it is a legal system and that there are procedural requirements that need to be adhered to. Um, and so part of that requires having attorneys who not who are familiar with family court law and procedure, but also familiar with domestic violence, so that they're able to incorporate their knowledge of coercive control, economic coercion into the arguments that they make before the court, and that they have the skills and training, um, and frankly, like dedication to really represent people in ways that are look like legal representation and not simply family court conciliation.
yeah.
Um, so that's one thing that I would say. The other thing you mentioned is, the vitality of survivors' lived experience, and that absolutely is a critical place for us as a movement to focus our attention. Um, Survivors have really intimate knowledge of the ways that they experience systems. And that knowledge needs to be a source for us as advocates and as people who care about how our family courts operate, um, to leverage that information and to create new approaches. And so at the Center for Survivor Agency and Justice, we have what's called a Survivor Advocate Advisory Board. And this is a group of people who are bringing their lived experience and also their advocacy experience to really create change. Because, we can't just, as much as we, as, folks in this field, who are attorneys, think that we know about things, and certainly we do, and we bring expertise and important skills. We cannot do this without partnering with survivors. And so that approach has been really important for us at CSAJ, whether it's the model of survivor-centered economic advocacy, where we're bringing together survivors' lived experience with advocates' experience about systems, so that people can co-create strategies that are relevant to survivors' needs. Or in the policy context, similarly, taking the lead of survivors. Our SOB at this, which is what we call the Survivor Advocate Advisory Board.
Love the acronyms.
Yeah, has created an entire policy agenda, survivor economic equity policy agenda,
Nice.
and has really been pushing that forward with organizing groups across the country. So
Nice.
that kind of leadership by survivors and partnership with survivors, I think, is really important for us as we reflect on how we can strengthen family court responses and other court responses across the board.
Yeah, definitely. I always say that survivors are experts to expert survivors. They're the experts on what it's like to firsthand live inside a course of control, from my perspective, and just on their will, like what they will, what they don't will, what they want, what they don't want, what works for their family, what doesn't. Whereas maybe, like for example, you are very well, obviously, knowledgeable about the legal system and sort of, statutory rates and what case law and doctrine and procedure, how to procedurally get there, right, from rights violated to rights restored, and research. And I have my own expertise, and everybody has their own expertise, but survivors are experts as well. And yeah, definitely. And so the system, so okay, so the system places, procedural demands on survivors when they enter the family court, but they're entering, number one, I always say they're entering, first of all, with their lifestyle probably severely degraded economically. They're just trying to figure out, how am I going to keep a roof over my kid's head, water flowing, the lights on, and food and medical needs, etc., right? And then also they can't necessarily really afford the legal support to understand what their rights are, and how to procedurally get there, because procedure is the vehicle, right? Um, and then also, thirdly, these two sort of predicaments that they're in are both a result of a continuation of the coercive control shifting forms, right? And so that makes survivors hyper vigilant, right? And I think the science, the psychology can explain why, because it puts them in fight, flight, freeze, or fawn, however their nervous systems have learned in their life to try to attempt to keep them safe. Now, if we cross compare this to the perpetrator of coercive control, they probably have an elevated lifestyle, right? Because they've taken, most of the money, so they're not worrying about housing, food, etc. And oftentimes I'll see that they'll buy a second brand new vehicle too. I don't know what it is about that, but I see that so often, et cetera, et cetera. And they can afford more than legal support. Some of them have multiple attorneys, and they have someone advocating for them, speaking for them to navigate this adversarial system. And they are not being coercively controlled. They are doing the coercive controlling, which I would argue is how they've learned to soothe their nervous system is by coercively controlling. And so they're not hypervigilant. They're opposite. They're calm. They're collected. And so the family court system, I say that this is the credibility inversion because they misinterpret that as the party perpetrating rather coercive control as being credible, reasonable, etc. And they misinterpret the survivor as lacking credibility, etc. And so I guess I just wanted to ask you what you kind of thought about that and um, yeah, just what your thoughts are on that overall.
Yeah.
That was a lot.
um, all good points. Um, so to me, some of this goes back to how we understand safety. And earlier I talked about the fact that there is no safety without economic security,
Yeah.
which is sort of at the core, right? We can't be safe without having access to the resources to make choices and to have the basic things that we need to be safe. So that is a huge determinant and deeply connected to economic security is that safety is an equity issue as well. So, and I mean that across a number of different identities, right? We know that historically and in the current day, women have less access to financial resources. We also know that communities of color, as a result of our economic systems and our history, um, are at greater economic disadvantage. We also know that folks who are maybe immigrants, LGBTQ folks, um, marginalized communities have a, are disproportionately experiencing economic hardship, right? And at the same time, we know that marginalized communities and women disproportionately experience domestic violence. So when you put those two things together, right, we know that economics is critical for safety, and women and BIPOC communities are at a disproportionate are disproportionately impacted by economic hardship and disproportionately experience violence. It makes sense that our focus needs to be, again, taking a look at safety as an issue of equity, making sure that resources and that our systems are aware of the ways that gender, race, ethnicity, sexual orientation, all of those things operate outside of the courtroom as well as within the courtroom. So I think that context and that framing of safety as an equity issue is really critical to thinking about our solutions as well. In terms of like some of what you were describing about procedural outcomes, you know, though the economic circumstances that people find themselves in, both as a result of living maybe in economic hardship, and then having that compounded by domestic violence, those economic circumstances play a critical role in terms of people's ability to access justice in the family courts. We talked before about, that economic abuse isn't just a one-time incident and that it compounds, right? So I often talk about it in terms of an economic ripple effect of domestic violence. And that's based on some research that somebody named Sarah Schoner had done long ago when she was doing her PhD. And she and I wrote an article on the economic ripple effect of domestic violence. Um, but really, just this idea that these economic impacts may start, during the relationship. It could look like job loss or credit damage or debt or a day of missed work. But then when you continue further in time, it's like leaving the relationship. So there are the costs of relocation, the costs of legal fees, um, foregone wages, housing instability, the cost of childcare, right? And then when you look way further into the long term, you're really looking at impacts that are going to last an average of 10 to 15 years. And those are mental health impacts, those are physical health impacts that, of course, have consequences in terms of people's professional development, their educational development, which then prevents them from being economically self-sufficient in the longer term. So all of these things are, really a cascading response. And the family courts responses to people entering, with fewer economic resources are either an opportunity to disrupt that hardship and create safety, or sadly, an opportunity to compound that.
Yeah.
And so, when I think about this economic ripple effect, I think part of the challenge slash opportunity for us is to think about, okay, so what would a positive economic ripple effect look like in the context of family court? Like, what would that look like if you have this, if you acknowledge that economic inequity exists in, society and in this particular relationship? What can family courts do to disrupt that and to ensure that people have the resources that they need to be safe?
Yeah. Well, that's my entire existence here because it's just like I don't understand because, again, this is for informational purposes. This is not legal advice. This is me speaking as a social researcher and policy analyst and maybe a former paralegal under the supervision of an attorney. But this is not legal advice. But NJSA 2A34-23, so New Jersey statutes annotated, says both parties are entitled to equitable access pending proceedings. And so it's like, I'm a little bit confused. And of course, there's, case law. I actually just learned about v. Baptiste last night too, about how I think the trial court they refused to even entertain a pendente lite motion and just took the income earners. Well, I'm paying, select household expenses, and so that was fine to keep her moving through the case. And she filed in 2014, and I think that was 2019, and and the appellate court was it? The appellate level was like, no, that's a dereliction of duty. You have to hear the pendente lite motion. You can't substitute. I mean, what a perfect breeding ground for coercive control. He gets to decide what household expenses are paid, and that is still happening today. I mean, to somebody I'm working with right now. But yeah, it's so both parties are entitled to equitable access pending proceedings. And so I would argue that once the initial complaint is filed, proceedings are pending and both parties are entitled to equitable access. And I understand the procedure is the vehicle in which to get from rights violated to rights restored. And so maybe the Supreme Court, which drafts here in New Jersey, I believe the rules of court, each year, maybe we need some really hard procedure there that puts a time limit on that because that happening for over a year is unacceptable. And I don't know, I almost think that statute, though, is almost procedure because it's pending proceedings. So if proceedings are underway and you're putting her through broad discovery and you're putting her through, custody and parenting time mediation, and she's going with only household expenses and he's going with an elevated lifestyle and brand new vehicles, it doesn't, I don't get it. I don't understand why, you know, I don't know. I just think if I was a judge and I had discretion, I wouldn't, allow that because, and I think it's a very simple, solve, prioritize the pendente lite analysis and very quick, especially in a single income household, especially where there's young children, but they don't, they just prioritize their deadlines and they don't make sure that she can safely and meaningfully participate. So I don't know, but I guess that's my
Yeah, I mean,
work.
yeah, I'm not familiar with that case, but
Yeah.
certainly this idea of like ignoring procedure um, is one that I think unfortunately is common. Again, underscores the need for there to be domestic violence trained and savvy attorneys who are
Yeah.
available and accessible to domestic violence survivors. Um, I think that's part of it. I think another part of it is this courtroom sort of a gap in understanding, again, the ways that economics is critical to people's safety. So lots of times I know we hear from courts, well, we're not talking, this is a custody hearing. We're not talking about economics right now. Um, or this is um, a temporary protection order hearing. We're not talking about economics right now, but you can't talk about safety without talking about those economic issues.
Yeah.
And while the longer term issues, yes, can be sort of resolved in time, even the immediate safety needs are going to be exacerbated if courts are not addressing those economic issues from day one.
But they treat it as a support dispute. That's the issue. And for me, it's like, I think it's artificial, especially, and I'm coming from this perspective of, marriage, right? And I view marriage as an economic partnership where income generation is not working equals income generation. Malamo vis Malamo or Malamo vis Malamo. I'm not sure how you pronounce it. I've heard it pronounced either way, but caretaking is equal economic contribution. So caretaking plus working, whether it's W-2 earning or a business, equals income generation. And so it's like now, okay, we file for divorce, right? And so why is the income automatically treated as the income earners? It's like it's so artificial. And then he gets to use the marital assets to lawyer up and to elevate his lifestyle. And somehow she has to go in there and prove over and over again. And maybe she doesn't do it perfectly or the right way. And so it's denied over and over again. And so yeah, there's no, economic safety, but it's artificial. Like, and she's probably still enabling the income with her caretaking. It baffles me. I don't understand. I don't get it. To me, it's pretty simple. 1 + 1 = 2. But over and over again, this happens, and then it just like cascades into, a bunch of consequences. Um, so I really, I don't understand. I don't get it. I don't understand why she's treated like she's a second class, partner to this economic partnership of marriage just because the parties like separate. You can't treat that as his income. Like she has been responsible for it being built up and is probably still responsible for it being what it is like to that day that they're in court. And but the family court just, does this time and time again.
Yeah,
Um,
I think that's a real mismatch between understandings of what gender equality is and how we treat people in real life, right?
yeah.
Um, Unfortunately, I think our court responses to um, divorce and family law have incorporated an understanding of equality that doesn't account for the ways that gender actually operates many times in
Yeah.
people's relationships and in the world. We
Yeah.
know that women um, disproportionately take on caretaking roles.
Yeah.
And so when we fail to acknowledge the resources that that entails, we're coming up with solutions that are like really more about an imaginary understanding of gender equality where people have equal access to economic resources
Yeah.
that, sure, one day that would be nice if that would exist, but that is not the reality.
Yep.
So I do think that courts, there's a lot of education that needs to be done, and that could really support judges in being able to make decisions that really connect up their safety determinations with people's economic circumstances. But that's a culture change.
Yeah.
And it's a culture change that will take a great deal of advocacy and a great deal of bravery too by attorneys who are willing to push the envelope
And they're not. A
in
lot of
their
times they're
cases.
not.
Yeah.
Yeah, they just want to fall in line. But um, yeah, it's like, yay, we've made advancements. Women can work and be treated well, in theory, be treated equally in the workforce, not in practice all the time. But then, of course, now in the family court, it's used against them once again. Like they're just in that double bind. And it's interesting because, and also something is like, well, she needs to go out and get a job so she can be economically independent. It's like, well, wait a second, hold on. He's interdependent on her as well, right? It's not when you have a stay-at-home mom and you have a income earning husband, just for example, right? Historically and still today, it's still that way overwhelmingly. Um, and so it's like there's this interdependence economically. And so the family court is almost treating it as, well, you remain interdependent with him and that you still provide the overwhelming caretaking that enables his income. And he just gets to stay, at his job, working stable, and he receives that benefit. But you, in addition to being economically interdependent, you go out and create this whole new economic structure where now you are a wage earner as well. And so you do this job and this job, whereas he just gets to be in this economic interdependence. It's like that's the great fallacy of saying that she needs to become economically independent. So does he, or he needs to, pay for that, benefit. But they allow this under the guise of it's temporary, even though it becomes the long-term operating regime or outcome determinative of this entire case. Or, I have discretion, or I'm narrowing the issue. And here's um, my whole thing on narrowing. If I have a 2x4 and I narrow it and I measure it, it's no longer a 2x4, it's a 1x3. So let's let's not pretend that narrowing is a permissible thing. But yeah, it's such an important issue. And my whole solution for that is I think we need judges and attorneys to follow the law. Like both parties are entitled to equitable access pending proceedings. And I think that's the solution. But to get them to do it, man, it's so tough and rough. But I guess it's where we need the advocacy to yeah, to really get them to see the importance of following that law. But
I
yeah,
agree. And I think that the family court system, it unfortunately does a particularly bad job of that
yeah.
because I guess,
Following the law.
yeah, following procedure, following the law,
Yeah.
um, and acknowledging and really understanding how economic abuse and coercion operates. And so
Yeah.
I don't know if this is, just to give you a sense of like other contexts where that maybe a better job is being done. Um, there are some strides that have been made at the federal level, also at the state level, in different economic legal settings where economic coercion has been and is recognized as relevant to people's legal rights. So, I guess most notably, like the Federal Violence Against Women Act, which is like the prevailing law that's been around now for over 30 years. Um, that back in its last reauthorization now includes economic abuse within the definition of domestic violence. So now the Violence Against Women Act recognizes economic abuse as something deserving of remedy that courts need to pay attention to if they want to get their funding.
Yeah.
Um, and that attorneys and advocates and police officers and all of the stakeholders need to be addressing as part of their response to domestic violence. So that to me is a bright spot, and certainly, again, there's a need there because laws don't self-implement.
Right.
But at least our federal legislature saw that as something that was deserving of protection, that economic abuse is a thing that's requiring of remedies. And there have been other spaces, again, where that's been recognized. So in the tax setting, we've also seen, relief, innocent spouse relief exists where somebody has been coerced into signing a tax return without their consent, or their information has been fraudulently used. There's tax relief for survivors who step up and are able to show that that's not that was not done consensually and that economic coercion was playing a role. Similarly, in the student loan relief context, again, there's been acknowledgement that when you are entering into a student loan without your consent, either by fraud or through coercion, you're not going to be held to that, and certainly not going to be responsible for getting an abusive person to comply with your efforts. So, there are opportunities for that, and states across the country have adopted different definitions of economic abuse into their state codes, both civil codes and criminal codes. So it is possible. And, I think part of that, task of attorneys in family court systems is really uplifting the other instances where this is happening, so that we're able to, again, kind of shift from what our laws tell us to what our courts are actually doing.
Yes. Yes. Very good. Such a good point. And so then really to tie this all up here, so the procedural outcomes and cascading consequences, you mentioned cascading, that's actually literally the title of the last section here. And so
Oh.
focusing kind of what happens over time. So when financial coercive control is not interrupted, early conditions often do not remain temporary. Instead, they become the foundation for long-term and compounding disadvantage over legal, economic, and personal domains. And so the progression that I have, seen, I think in the research and that I see in practice is that okay, so she cuts off the abuse happening, maybe psychologically, physically, sexually, etc. And then, as we talked about, it does not stop because it's coercive control. And so the goal is power and control over the target or the survivor, rather. And so it just shifts form, and I see often financial. But then I'm like, because of how the family court addresses it, which we just talked about in length, it doesn't stop it. It almost allows it, or does allow it. And so then what I see is because they don't interrupt it, they don't put both parties on equal footing, it cascades into every other consequence, imaginable long-term financial harm. Then the perpetrator of coercive control is emboldened and positively reinforced. And quite frankly, the structure is set up to allow them to engage in litigation abuse. In finances, litigation. Oh, what else am I thinking of? Finances, litigation. Oh my gosh, it's total. My mind is going blank. Custody and co-parenting. That was the one. That's a big one. I've seen women who, one of the testimonies on the nonprofit's website, it just breaks my heart every time I hear it because this is what happened to her. She was cut off financially, and then he went and did a order to show cause, like an emergent order for custody and co-parenting, and she lost her kids that day, and she had 2 days to prepare. She had no attorney, and yeah, and he did, and she lost her kids that day. Another woman, because of the financial abuse, it psychologically broke her. and she went to go get help. And she's actually an associate professor at a university. But because he took all of the business income and all the assets, she just had her salary and it wasn't enough. And so she went and got help. And um, and he did the same thing, and he's had her kids for 2 years and she's not able to see them unless he lets her. But now he has a new girlfriend, and so he has really, I guess, no use for her. And then she's like, can I please like temporarily just have even supervised visitation with my children? And the judge is like, no, we'll wait till trial. He can have watch the children whoever he wants or whatever. And so, and there's just many other, stories like that. Another woman who's in court like a few times a month or at least once a week because of the litigation abuse, and she ran out of funds, and he has infinite, well, not infinite, but a lot more funds. Um, yeah, and so my whole point is that domestic abuse that turns financial, and if the family court doesn't interrupt it, it cascades into a whole bunch of other consequences. And I guess I was just wondering if you, again, another long question, loaded question there. But do you have anything from sort of your point of view and expertise that you have to say about that or contribute to that?
So, I mean, I think that the consequences of when I look at this idea of there being an economic ripple effect of domestic violence, um, that precedes family court, and also family court intersects with that. Excuse me. There are multiple ways where different systems that survivors interact with can either interrupt the economic harms, the economic ripple effect, or they can compound it,
Yeah.
and contribute to it.
Yeah.
So, economic abuse is not just an individual harm, it is often facilitated by, made possible by, inflicted by court systems and other social service systems and financial institutions sometimes as well. Um, so yeah, when you share that with me, it's just again about this question of like when we look at the economic abuse ripple effect, how can we ensure that the family court system is an interrupter in that economic ripple effect as opposed to an enabler and
Yeah.
a harm doer itself.
Yeah.
Um, because you're absolutely right. Far too often people are um, experiencing, when they are seeking help, rather than being able to access that relief for themselves, for their children. The very systems that they're asking for help are inflicting harm, um, oftentimes more harm than what they had even experienced prior to seeking help from the courts. So, how do you what is the role of family courts in interrupting that? Us as like each of us kind of taking an account of where we sit within this ecosystem, whether we're advocates or attorneys or judges, custody evaluators, um, landlords, people working in financial institutions, like taking stock of where we are, what power we hold, and how we can ensure that our responses to domestic violence survivors are supportive of their economic security and safety as opposed to, um, harmful. Um, so a lot of in the family court context, there's obviously a great deal of room to better incorporate economic considerations into custody proceedings, into other family court proceedings. Um, and really, I think it comes down to people kind of wearing their what I often call like economic justice lenses. They're putting on those economic justice glasses, and thinking about, okay, here I am as an advocate. I'm sitting here with this person. What does safety for them really require? It's not just, a short-term stay away order. It's also needs to be thinking about what resources they need to keep themselves and to keep their children safe. And so at that intake, that's going to impact the questions that I ask. That's going to impact, further down the road, the strategic thinking that I'm doing alongside this survivor, and the ways that I'm voicing arguments to the court. Best interests of the child. Well, best interests of the child includes access to economic resources so I can have a roof over my head, so I can have food and be able to just live safely. So, that's from an advocate perspective, but of course, everybody who's part of that system needs to be taking account of what role they might play in better centering economics.
Yeah, definitely. So important. So before we close, I want to just ask a few final questions about you want people in positions of power and others living through similar experiences to understand. So, what would you want judges, lawyers, policymakers, and other people in positions of power to better understand about financial coercive control and its effects?
Yeah. I think we've talked about a lot of this in different shapes and forms throughout our
I
conversation.
know, I'm sorry, my repeat
No,
question.
no. And so it's really a synthesis of some of what we've talked about. I think at its core, I would want people to understand that there is no safety without economic security.
Yes.
Um, and that the goal, if our goal is safety, um, then we need to be incorporating economics into the work that we're doing, wherever it is that we sit.
Mhm.
Thinking about, for this particular survivor sitting in front of me, whether I'm a judge or an attorney or an advocate, what does safety require? Um, and making sure that we're doing all we can within our power to help them to access the financial resources that they need to be safe in the short term as well as the long term. So, what would I want advocates and attorneys to know? Again, to kind of put on those economic justice glasses when they conduct intakes, counsel clients, go to court, uh, present testimony to really illustrate the economic impacts of past abuse as well as what's needed in the longer term, and to incorporate that into their requests for relief. Um, in terms of what I would want judges to know, you cannot sort of leave economic issues for another day,
Yeah.
because that means leaving safety for another day.
Yes.
So in making determinations where safety plays a role, judges need to be thinking about how economic coercion has played a large part and will continue to play a large part in this person's life and their ability to be saved, so that as a judge, they're crafting outcomes or orders that really attend to those economic risks, and give that particular survivor the resources that they need in order to be safe in the long term. Um, Policymakers also needing to consider how the experience of economic coercion functions in survivors' lives. So some of the concepts that we have around sort of equal bargaining around contracts or around loans, or other economic issues, are going to be different when economic coercion is playing a part. And so really being attentive to creating policies that, again, consider economic coercion and make either exceptions or provide relief for individuals who have experienced economic coercion. Um, yeah, that's what I would want folks in each of those positions to have at the front of their minds.
Very good. Yeah. And what would you want to say to someone who is experiencing navigating the family court system and experiencing financial control?
Good question. Um, First, I think is just that the family courts were not built for domestic violence survivors. They weren't built for the most part, they were not built for women. They were not built for people who are otherwise marginalized.
What were
Um,
they built for?
Good question. Um, the family court sort of culture of conciliation is at
Mm,
odds with the experience of domestic violence
yeah, there's
survivors.
no conciliation when somebody's trying to have power and control and trying to have the upper advantage and keeping the other one entrapped. Yeah.
Exactly. Their conciliation presumes that there's equal bargaining power and
Mm,
that things can be easily negotiated. But domestic violence, by its very nature, is all about unequal power, power
mm,
over. And so that type of framework, which unfortunately tends to be the culture of family courts, is a really dangerous one for domestic violence
yeah.
survivors. And I use that word dangerous like very deliberately, right? It's not just
Yeah.
that it's frustrating or
Yeah.
it's actually
Dangerous. It
dangerous.
can be lethal, right? It's on a spectrum, right? Low, medium, high, but you never know which one's on the higher spectrum until it happens because doesn't a DV or coercive control not end until the victim's life ends, or am I wrong about that?
I think having to manage that is a lifelong job. Absolutely. Yeah.
Sorry, I interrupted. Go ahead.
No, no. So yeah, I would say to survivors that, you need and you deserve a family. You deserve an advocate and an attorney who
Hmm.
understands that mismatch that we're talking about and who can even the power imbalance that exists in that setting.
Yeah.
Um, as well as someone who can argue your case in a way that really showcases the ways that coercion puts you and your child at risk.
Yeah.
Um, that is really critical, really important. And anybody who disbelieves you or who questions what you did financially or otherwise is not an ally, and not somebody who you should be working with.
But
It's
yet
okay.
they're stuck with them.
It's
Yeah.
okay to change your attorney too. It
But
is.
yet, if they're being financially controlled, they can't.
Um, you may not have the resources to pay for an attorney.
Yeah.
Yeah. But I would say that having an attorney who is abusive is worse than having no attorney. Um,
Oh, yeah. That's a good
so
point. That's a good point. Yeah, having to go pro se. Yeah, man. Yeah. That's such a yeah, because that's what happens a lot. I see these survivors, they are it's like actually a very known thing I've found. It's like they try to leave the coercive control relationship and then the relationship with their attorney becomes very coercively controlling and then they're stuck because they don't have the finances to hire a new attorney
mhm.
or their legal aid. And so it's like, where are they gonna, go? And then it's so horrible. But I guess that's why I do the work I do and you do the work you do. But it's an interesting sort of thought you brought up about the family court. Yeah, maybe the family court shouldn't be a court of, based on conciliation. Maybe it should be a court based on evening the power imbalance. Maybe that needs to change. I'll have to do some looking into like where that even comes from. And how can that be changed? Yeah, my thoughts are brewing.
I think in most contexts, there's an assumption that courts are going to adhere to law um, and procedure. And for a number of reasons, I think that some of those things have been put to the side in the family law context in favor of conciliation, negotiation, um, with a misunderstanding that that's going to serve children's best interests, right? Like that it's better for there not to be sort of any sort of adversarial proceeding or because of the children. And while that maybe, that may make sense in certain circumstances where parents are separating or getting divorced just because it didn't work out. Um, in situations where where there's domestic violence, that's just not an appropriate response. So
Yeah.
I would say the family courts need to do what all courts do, which is, proceed under the laws that exist, and also, adhere to the idea that people have constitutional rights that need to be respected. Um, yeah, that is the whole reason why there are courts, as opposed to, other we could otherwise it could be another entity helping to resolve a problem. But a court, the idea behind a court is that it's going to follow law.
It should be. It should be, yeah. Um, so is there anything important that we did not discuss that you think people need to understand?
Um, I think part of what I would share is that these economic issues are um, broader than just the family court setting. And I guess I would encourage people, whether they're survivors themselves or advocates in this work, to really start thinking about the economic issues very early on. In fact, economics should be part of people's safety planning even
Yes.
before they have left a relationship. Um, Thinking carefully about what resources people have, what the risks, the economic risks, and the economic opportunities might be, um, and partnering with an advocate who's able to kind of hold that context alongside you is really important. Being able to do things like take a look at credit, thinking about some of these debts, thinking about what an economic plan might look like in the short term and longer term. Um, Again, so that this family court process, is part of the picture, but it fits within a broader context of economic safety planning.
Nice. Very good. Yeah, that's such a good point. And then where can folks learn more about you and your work?
Oh, yeah. So, as you had mentioned during the introduction, I am the founder and the executive director of the Center for Survivor Agency and Justice. CSAJ is a national organization that works to advance economic security for survivors of domestic and sexual violence. Um, we have a website that is csaj.org. You can certainly go there. We provide support to attorneys and advocates in the field. We also work alongside community-based organizations that are really trying to center economics in the ways that they do their work. And we also, through the leadership of our Survivor Advocate Board, push for policy and systems changes that center survivors' economic lived experiences. So to learn about all of those different ways that CSAJ does its work, you can go to our website. You can also email us at info@csaj.org.
Perfect. Awesome. Well, thank you so much for being on.
Yeah, thank you. Appreciate your work.
Thank you. You too.
Thank you for joining us for another episode inside of our series called When Coercive Control Turns Financial, the Family Court Response, and the Cascading Consequences. If you are an organization or an event and you are looking for organizational consulting, speaking, or training so you can understand coercive control better, so you can respond better, I want to invite you to go ahead and visit me at crystalfidelli.com. If you are an individual leaving coercive control and you would like support navigating, I want to invite you to go ahead and also visit me at crystalfidelli.com. And if you are interested in specifically supporting You Made a Way, it is the 501c3 nonprofit that I founded and I am the executive director of. If you are just as passionate as we are of making a way for women and children who are leaving coercive control when it turns financial, I want to invite you to go ahead and visit us at youmadeaway.org. And we hope to see you back here next time for another episode of When Coercive Control Turns Financial, the Family Court Response, and the Cascading Consequences. See you then.